Welcome to News Night. I'm Lanre Lasese. Tonight, our focus is firmly on the 2027 general elections. We've just witnessed political parties conclude their primaries for elective positions at both the state and federal levels. It's been an eye-opening process, revealing much about the state of internal party democracy, the dynamics shaping Nigeria's political future. Amidst this development, a judgment delivered by a high court in Abuja has introduced a new twist, one that appears to challenge the independent National Electoral Commission and raises fresh questions about electoral governance in the country. Now, these are some of the issues we'll be unpacking tonight. Joining us is a guest with extensive expertise in electoral governance, civil society advocacy, and legislative reform. Is the Executive Director of Yaga Africa, Mr. Samson Itodo. Thank you for being our guest today.
It's always a delight.
Always lovely to have you. And I would like us to go directly into it. We've spoken about pre-election, all the arrangements and all, but now it appears we're a lot closer than when we spoke the last time. Political parties have held their primaries. A lot of them have. A few are tidying up as it is. I would like to get your opinion. So far, how far?
Well, I think with respect to the primaries, you clearly see what perhaps could pass for a travesty. A travesty in every respect, because most of what is termed as candidate selection were basically coronation. And I'd argued this prior to this particular primaries, that what you see is imposition of candidates, especially at a scale that we haven't seen before. We now have new concepts such as geometric counting. And that, really undermines the Electoral Act, especially looking at some of the provisions introduced in the Act. And so you ask yourself whether we are not making a mockery of the entire concept of democracy. And it's just sad looking at the primaries that have been conducted so far. A lot of them are first in gross violation of provisions of the law, but secondly, they do not meet, the standards of transparency, of accountability and integrity. Because how do you explain situations where a party adopts direct primaries? First, it doesn't disclose its guidelines for the conduct of primaries to the aspirant, talk more of its members, because INEC's regulations are very clear. If you check paragraph 22, sub 5, talks about what guidelines and information that parties are supposed to present to INEC. When you also look at situations where people who have indicated that they are seeking the nomination of a particular political party, their aspirations are suppressed. And so you ask yourself, why is it that parties went against the will of their members and imposed candidates through the whole vehicle of consensus candidates, which in my respectful view, based on what I have seen and have observed in the conduct of this process, is just a back channel way of imposing candidates. And it's just really unfortunate.
Let me get you clearly. When you say it's in gross violation, which specific points are you...
It's very clear. So what you saw in this process is what I called front-loaded consensus. The Electoral Act is very clear as to the procedure and the steps for consensus candidates. It said first, all cleared aspirants, and for you to be an aspirant, you must secure the nomination form. Yes. You must also pay the prescribed fees. You must have gone through screening. And then once you are cleared, the only way a consensus is valid is if it comes first from cleared aspirants. Those aspirants, all of them, must voluntarily withdraw and endorse one candidate and say, this is the candidate that we endorse. And afterwards, that endorsement shall be ratified by a special convention. What we saw is front-loaded consensus, where one, in some cases, forms were only sold to anointed candidates. In places where forms were sold, other candidates were muzzled out of the race. You didn't give them the opportunity to go through all the processes. Why? Because parties who are undemocratic were scared of competition. And competition enhances the quality of democracy. So you cannot say that is consensus. A situation where it's become a practice within our parties where you do what? You front load consent, of withdrawal in the forms that you submit to your political party. That cannot be a democratic primaries, because what parties should do is to create a level playing field for all. You don't want to talk about the situation where, voters and party members voted a certain candidate and then results are substituted. There are some parties that are unable to announce their results because of what? Because there are several mutilations actually happening across board. It does not mean that in some instances there wasn't any keen contest. There were places, and what I think that is a biggest takeaway from this process, I think the heroes of this particular cycle of primaries are those members of the parties across board who, when the parties decided they were going to adopt a certain mode of primaries, they pushed back and resisted. They are the heroes of this particular cycle because they resisted every attempt by hegemons in the parties, to impose candidates on them and subjected those processes to what? To direct primaries. So they are the heroes. The other one is also all those aspirants who were intimidated, who were forced, they tried to cajole them to pull out from the race because of certain anointed candidates. For defying, that pressure, that is what makes democracy interesting. That's what strengthens democracy. I don't want to talk about some of the figures being bandied around, even though they are being questioned. I'm sure we'll talk about that. But quite frankly, everything you see happen in this entire primary process is just a manifestation of the character of our political class and how they think about political power, that they are not accountable to the people, that if they want power, they will get it at all costs, even when they are rejected by the people.
I'm trying to understand if you're saying this cuts across all political parties.
Absolutely, it cuts across all the parties. You see some form of imposition across all the parties. So it's not one thing that is peculiar to a particular political party. It cuts across broad. So I think it's a fundamental problem with our political class, and then by extension, you can say our political system, because what happened in the primaries does not resemble democracy. And let's not make any pretensions about it.
I'm interested, like you said, these were some of these outcomes were following the amendments to the Electoral Act. And it's painful from what you're saying now to see that it looks like all the work done for that document didn't affect the outcome.
First, there was even a problem with the document because there are certain provisions, in the act that I thought that first, the fact that the act was even passed late after a process that commenced right after the election was problematic in this respect. The second thing was the timelines that were so compressed. The National Assembly had no business amending those timelines. In fact, review of timelines was never an agenda item on the reform agenda. They only introduced it. They amended those timelines on the floor when they were passing the law.
Yeah, but it came as a result of the fear that the election will come.
No, that was way before. The only thing that was amended was the issue related to what? The section, the dates. The date of the notice of election, which was 360 days. Previously, 360 days was brought back, to 300 days. But when you look at the whole point about list of timelines, so for instance, on section 29, you say that INEC will submit a list of candidates in 120 days. But on one hand, you say that campaigns will start 150 days before the date of an election. So campaigns will start way ahead before we even know those who are on the ballot. Why? Because of the 11th hour changes that were made on the floor, of the National Assembly. They compressed the timeline so well that makes it difficult for the election umpire, to conduct his processes. So there's a problem, with those time frames, and we can't gloss over it. But when you look at things like submission of the register of members, quite a novel provision helping to sanitize the process. Now, the bigger question is, are we going to maximize the utility of that particular provision? Because, for instance, parties submitted registers. We don't know, as a people, what's the authenticity and the credibility of those registers. Because one would have expected that once parties submit the register of their members, INEC will publish those registers. The same way INEC publishes voters' register. You publish the register and then ask and try to do a deduplication process just to ensure that names are not appearing on multiple registers. Because the question now, you can see members of some political parties, because they were either rigged out or they were substituted or they were oppressed and intimidated out of a political party, are now candidates of another political party. And the question to ask yourself is, at what point did these individuals obtain membership, of this new party where they have now secured their nomination? At what point did that happen? And that's exactly. That's why this deduplication process that INEC needs to conduct would have, so that if you see names appearing on multiple registers, you raise it and then you take action about it. But we unfortunately, maybe for want of time or one other reason, we don't know. Again, there is no official statement from INEC as to the total number of party members that are contained in the registers. So we also, those are some of the gaps that really need to be fixed. And so I doubt if we'll maximize the utility of that particular provision. But again, it's a new law, so let's see its implementation. And I'm sure there will be lessons that will be learned from this side.
We spoke about the issue of consensus, but the issue that I think worries a lot of Nigerians, and I think you touched on it, is how blatantly the direct primaries were being done, especially since this is not a novel primaries type.
Yeah.
We've had it before. What is happening now that we're seeing this, what you call the geometric, and is it that there is, from the way it should run, the INEC doesn't have a role, the political parties are left to just do what they want?
The greatest danger for our democracy is to allow political parties to regulate themselves and their affairs, because that was not the conception of the Constitution. The Constitution is very clear that it vests power in the National Assembly to make laws for the regulation of political parties. And at every point in time, INEC is not just an institution that registers political parties. INEC is a regulatory institution. I'll be shocked to see that INEC officials monitor these primaries and then they legitimize its outcome. Then that will be complicity on the part of INEC officials. Because this whole geometric counting, you also see some violations of the law and INEC's regulations, and INEC cannot sit down and just watch his hands and say it cannot do nothing. No. If the parties have violated provisions of the law, then INEC needs to regulate. It needs to take action on them. I will be surprised, and I'm sure the public is watching INEC, to see what will be its statement and its position on some of the primaries that it observed or it monitored. Because those primaries that we saw, in certain cases, we deployed observers, sister organizations deployed observers. Okay. There were no primaries in those locations that they claimed that those figures came from. Nothing. There were observers that went around doing some of these primaries and nothing actually happened. So where did those figures come from? So we'll wait to see what INEC will do. But INEC also has to share part of the blame. Because when the regulations and guidelines for political party primaries, when was it released? There are certain provisions in the regulations that I would say most of the parties didn't meet. And I've referenced the fact that the names, in certain cases, that the guidelines of the primaries are meant to be published on 2 national dailies.
For each?
For each political party. How many parties complied? So when you see litigation, because if the guidelines are very clear about how the counting will be done for direct primaries,
do we need to have something drawn out to say how counting should be done?
Of course, it is clearly stated in our regulations and guidelines for elections how counting shall be done. There are different procedure. Once polling units is closed, once voting has been done, the first thing you do is called sorting. You sort the ballot papers.
Yes, that's it.
And then voting. You count.
Yes.
It is a procedure.
True.
That is clearly outlined in the law.
True.
In this instant case,
for direct,
the parties didn't in any way, and I don't mean the ruling party alone, check all the parties who conducted direct primaries. How were they counting those people who showed up? How? 1, 2, 3, 4, 20, 50, 1,000? Come on. We should have respect for ourselves because the entire world looks at this and we make a mockery. And our politicians don't understand the damage they're doing. If as simple as your own internal party primaries, you cannot just manage the process of counting. How do you expect people to trust you when you speak to them, even in the international community? We take these things and then you see political leaders grandstand and with confidence legitimize this criminality.
Yes.
And they do so boldly.
They described it as near perfect.
It is simply because the society encourages that. If we don't rise up and condemn this, I bet it will become the norm. It's not the first time, but this scale, the fact that it's not just peculiar to one party, that other parties are following suit, is really disturbing. And everyone should be worried at what our political class want us to accept as the norm. This is a time not to renegotiate our values. That what transpired in these primaries is highly condemnable and it should not be accepted anyway. This cannot be the story about Nigeria's candidate nomination process. I think as a people, we deserve better and we can do better. But this charade is totally unacceptable.
Unfortunately, because of the time frame, it appears there's nothing we can do with it, and it looks like the process will continue.
No, but the party members, that's why you have INEC as a regulator. Why is INEC supposed to monitor those primaries? Was INEC there when this geometric counting was happening? 10, 15, 1,000? If INEC was there, INEC that counts ballots on the election should know that this is criminality of the highest order. And so if they didn't raise objections, when they received the names of those candidates, don't forget, Section 29 is very, very clear that they have to be validly conducted primaries. Validly conducted primaries. This is why the regulations compels political parties to submit their guidelines for the primaries. But ask the aspirants that participated in these primaries for most of the parties if they ever cited the guidelines. They didn't, because the parties do not have any regard for transparency, for accountability. The entire process was captured, and I wish it was captured to present popular, competent candidates with capacity, and competence. Unfortunately, that is not the case.
Okay, so I would like us to go, because outside these issues, we also have a door that has been opened now with the issue of the judgment in the case from by Youth Party against INEC. And that has opened another door now to what this whole process has been, or whether it's closed or it's not closed. So I would like to hear from you. You've looked at that judgment. You've monitored elections. You also understand how the plan was to see how we could have credible elections come 2027. But with this judgment, what is your take on the judgment and its implication?
I think at Yanga Africa, we reached a position on this. And there are three things. One, that political parties have a right to assert their rights when they have grievances about the conduct of INEC in the management of electoral affairs. And so when parties go to the court, to contest some of these actions, I think it's a welcome development. That's what judicial review, it's about.
Yes.
The second point is that when you look at that judgment, and you said, yes, it's thrown spanner into the woods, or it's opened a window for defections. When you check, what did the parties actually went to ask? They felt that the timetable was too compressed. And by the way, our position at IGA Africa is that this is the first elections in recent times with the most compressed timelines.
Okay.
And because the timelines were compressed, one of the things that we expected was that there will be broad-based consultations and consensus between INEC and political parties regarding fixing some of these timelines, just in a way that it encourages, participation, but not limit participation. And I think that's where, a lot of work needed to be done. But when you look at the judgment, when it talks about whether INEC erred in law, the bigger question is, when you look at decided cases of the Supreme Court and also INEC's constitutional powers, INEC has the constitutional right to issue regulations and guidelines, even by virtue of Section 70 of the Electoral Act. But INEC also has the independence. And when you have independence, the Constitution gives you some discretion. And this is what people need to understand. That the way the law is drafted, it's drafted in a way that list of candidates shall be submitted not later than 120 days. It doesn't stipulate the earliest date. Unlike the conduct of elections, where the Constitution says that elections shall be held not earlier than 150 days and not later than 30 days before the end of a tenure. So the lawmakers decided to say not later than. And the reason for that is before you submit the final list of candidates, there are several activities that must happen. First, you need to conduct primaries. And the law does not provide the time frame for the conduct, of primaries. It talks about when you conduct primaries, you submit the list and the particulars of the candidates 21 days after the primaries. INEC will then publish those names, and then there will be room for objection. So there are several activities that needs to happen. But the question is, could the parties have conducted primaries in June and it will still be legitimate? The answer is yes. Could they have conducted it in July? The answer is still yes. But the question is, INEC exercised its discretion under the law to say, by virtue of some of these activities, there is a great need to stipulate this time frame. What I thought the commission would have done was to sit down with the parties to say, this is our proposed time frame. Because of so. However, if the parties say it is too compressed, then you can move the time frame. You're still within, the provisions of the law. But our recommendation has been to INEC that in exercising discretion, you must exercise discretion in a way that it encourages participation and inspires trust and confidence on the stakeholders, but not shrink the space so that political parties are unable to perform their role and their function in the electoral process. Well, INEC has appealed and is contesting based on about 9 grounds. But as you can see, there's also another judgment by my Lord Justice Omotosho, who talks about, recognizing INEC's timetable as legal, but also urging INEC that there are instances where it must adjust, the timetable to conform with the provisions of the Act. For instance, when you look at the timetable, campaigns will start not earlier than 150 days and end 24 hours, right? That's what the law says. But the timetable puts it at 2, and if you calculate it, is more than that. So I think that those reviews and revisions can be made. But where we are now, is there's a confusion in the system at the moment, and this needs to be address. Well, INEC has applied for a stay of execution.
Yes.
The court has not fixed the time frame to hear that plea, but now you have another judgment by Justice Omotosho. So there's just a lot of confusion. And one is actually forced to think that maybe this confusion is also part of the political strategy for this particular electoral cycle.
Could this have been the plan all along, all this litigation at this point?
No, it has always been part of the process where you see frivolous litigations. And I'm not saying this is frivolous. I'm just saying that you see frivolous litigations that are meant to throw spanner, in the woods of preparations. Because at a time when, there should be some level of organization, the entire political system is saturated with quite a lot. We started with the whole debate about the time frame of the elections. We went to revalidation exercise, and that was suspended.
Yes.
And then we had status quo antebellum. Now you have different political parties, at least most of the opposition parties, having internal leadership crisis.
Yes.
And then now you have conflicting judgments that has been part of this entire process. And one of what INEC is also challenging is this deviation from the whole doctrine of stare decisis with judicial precedent and whether there is a deviation. And that's the argument that INEC is actually making. And then you have a Justice Omotosho. So you see there's a lot of confusion, in the system. And if you have courts of coordinate jurisdiction delivering or conflicting rulings, it creates confusion. So which one do you obey at the end of the day? At the moment, when we should be spending time, asking questions about the credibility of the candidate nomination process
the primaries,
and the state of INEC's preparations, we're now debating the whole judgments coming from the Federal High Court. And this will go all the way
and
to
do
the
we
Supreme
have
Court.
that time?
There's no time. We have compressed timelines. You have a new Electoral Act. You have a relatively new Electoral Commission. We have not seen the regulations and guidelines for the 2027 elections. In fact, you have off-cycle governorship elections
coming up.
So just 25 days from now, or even less than that. And so there's a lot within the system. So I think that, to a large extent, it's perhaps one of the strategies. Overwhelm the system, make it difficult for citizens to ask accountability questions, and there lies the pathway where you can manipulate, the entire electoral process to deliver a certain electoral outcome.
I think the scare for a lot of people is even the whole possibility of it throwing the election into a state, or the country into a state of confusion as regards whether elections will hold or not.
I think it's in our best interest that the election actually hold. We shouldn't, if there's anybody working, whether directly or indirectly, to make these elections not hold, I think they need to have a rethink. In the interest of our stability as a country, the election, should hold. However, the quality of the election matters, because if the election, is manipulated, and if there's no basis for people to trust, you cannot predict how citizens will react, especially given the current state of play. And so it's just unfortunate that our political class are taking Nigerians for granted. And I would caution that they should not underestimate the determined will of the Nigerian people, to reclaim their country from a predatory political class that wants to do what? Do everything, both in and outside the books, just to retain or secure political power.
One thing that came out immediately, because the news of these judgments, or especially the first judgment, when it came out, it was towards the end of this primary cycle.
Yeah.
And despite, like we say, all the failings we seem to have identified in the process, it looked like one way or the other it will be done. If you were going to challenge it, you will challenge it, and then we'll move forward from that. But that whole last minute inter-party or running from one party had been taken care of. This judgment appears to open that door. And you're a lawyer. If somebody now depends on that judgment and says, okay, because the judgment threw open the door, he has now left his party, he's joined another party. What do you see playing out?
But then the question is, Section 77 is very clear that the party register must contain the names of those who will vote and those who will be voted for.
Yes.
So the bigger question is, for those who cross carpet or those who defect to another party, are their names on the register of that particular political party? If the answer is in the affirmative, in other words, if their names are in both registers, what is the position of the law? And that's what, they proposed an earlier amendment to the Act that sought to criminalize dual membership. Yes. But it's inchoate, so it's not law. I guess that there's an exploitation of the gap within the law for people to move. But the question also lies in the fact that INEC has a critical role to play here, but also the judges and the judiciary. And that's why when you think about the triangle or the quadrant of compromise in an electoral process, you also require a quadrant of consensus to do the right thing that is necessary. And what I mean is, if INEC, as the regulator, decides to deduplicate the register and be open about, the management of the register and what they find in the register, just to even check, did the parties comply with the format
that
was meant to be, that the Act provides? Names, sex, biometrics, NIN. Did INEC analyze the register to see that it conformed with the provisions of the Act? Then also, the primaries, because those other candidates that cross carpet, they did what? They conducted primaries.
True.
The question is, which register did they use? Because Section 77 is very clear that only the register that was submitted to INEC shall be used for the primaries.
Yeah, but there's some that are saying now that with this judgment, it opens the door that issue of the date of submission was too early.
No.
Which means that you can now submit.
The law is clear. It says 21 days before the date of your primaries.
That's the guideline.
No. That's the provision of the law. The Electoral Act says 21 days before the date set for the primaries. Okay. If you recall, INEC had fixed a date for the submission of what? Of the register.
Yes.
The parties opposed it because the literal interpretation of the provisions of Section 33 or so, Section 77, is that the register shall be submitted 21 days before the date of primaries.
That the parties chose.
So if a party chooses 30th as its date of primaries, it is 21 days before 30th, which was why INEC it did issue a statement saying, following the meeting with the political parties, that particular time frame will be based on the 21 days before the date of the primaries, which in any case, INEC had said a certain date. And that's why INEC issued a statement to say all the parties complied. So if all the parties complied, it means that register that is with INEC is the register that will be used.
Wait, my brother. Okay, so all the parties that intended to put forward candidates were the ones who submitted primaries. The point I'm making is that some people are now saying that since some parties did it, does this not open the door for them to now, submit a primary, fix a date, and now we now have all these issues with new primaries,
But you see, INEC has filed for a stay of execution.
Okay.
And quite frankly, because INEC said 21, I think it was about 21 parties. I don't have my figures.
Yes.
Right, about 21 parties. So perhaps you have only one particular political party. But the timetable is a series of activities and events. And if you look at Justice Omotoshaw's own judgment, which is a judgment from a federal high court. And so these are two courts, of coordinate jurisdiction. Actually says that timetable is legal. And this is one of the things that we try to avoid, that we should as a people try to avoid. This confusion is absolutely needless. We're just overwhelming the system, and we want this entire system and our democratic project to actually crumble. And I don't think that is the right path, because all of this confusion, is going to further, to a large extent, even discourage voters from taking interest in the process.
That was where I was about to go,
because
I don't know.
It looks like everyone is confused. We cannot say. If you have conflicting judgments, and the question is, which is actually enforceable? Why should we have conflicting judgments? Let's say the judgments are actually reinforcing each other. What I thought that Justice Omotosho would have done was to take judicial notice that a broader judge has issued a ruling on this particular matter and just, concur. But some of the rulings from what we have seen in terms of the CTCs, really puts further confusion in this system. And what politicians want is to have confusion. They only thrive when there is confusion in the system. And this is something that as stakeholders, especially civil society media, we've got to rise up, and put our political class where they belong and really insist that this democracy needs to be shielded. And it has to be shielded even beginning from this primary process, because these institutions are trying to damage our democratic process, and we would not let it happen.
You're a lawyer, so I think I would like to ask you right now, if you look at where we are right now, you've mentioned the possibility, you would have thought what INEC should have done. From what they've done now, how long along the road is this going to take us? Because I know, like we say, this is court of first instance. This thing can go all the way to the Supreme Court.
It can go all the way to the Supreme Court.
But what do you see as the most feasible outcomes from all that we have on our hand right now?
As a student of election law, one thing I know for sure is that I know the jurisprudence.
Okay.
And the jurisprudence is very clear that the courts have always protected INEC's institutional independence.
Okay.
And I know the court will uphold, decisions taken by the Supreme Court on INEC's independence, that INEC has the independence to issue the timetable based on the provisions of the Constitution. I also know that because that's the position of the law, that when in relation to timetable, INEC does what also has the power to issue those timetables. But as long as it doesn't conflict with the provisions, of the Electoral Act. And what INEC did was to exercise institutional discretion. But in doing so, it needs to cast its mind back to what's the implication of that. And I did say previously that in this particular instance, what I'd expected that given that we had compressed timelines, given that this was a new act, INEC should have sat with political parties to look at time frames that will be convenient for the parties. And I still maintain that the primaries could have still been extended till June, till July, right? And we will still be fine as a country. Because I don't see what sort of, what extra administrative burden that it places on INEC. Again, in the drafting of the law, it only says not later than. It doesn't say not earlier than. So these are certain gaps within the law. But I quite frankly, I think that the train has already left the station. A lot of the actions that have been taken are legal. Even if it gets to the Supreme Court, if I know our electoral jurisprudence quite well, I doubt there will be a deviation from that particular judicial precedent that had been established in a couple of cases.
Some people will say this whole situation we found ourselves, we can lay the blame very firmly on the lap of the National Assembly.
It's the politicians.
And that, so I'm wondering, going forward, what's our takeaway, what's our learning from this? Because, we've discussed this before, that it appears we've turned it into a ritual, that every time after an election, we will amend the Electoral Act. And so that is expected that we're still going to amend it, at least seeing from some of these things, to try and make it better. Yeah. So if you were to look at it now, what's our takeaway from here that would say must take place next time to make sure we don't run into this sort of quite mild.
I think that one biggest takeaway is there's a fundamental difference with reforming the provisions of your law and electoral reform. What we have been doing is just reforming, just changing the laws, but we're not reforming the entire electoral process. So you cannot say it's electoral reform. And what I simply mean is we need to ask ourselves, questions about our institutions. We need to ask ourselves questions about our political parties. We need to ask ourselves the bigger question about what kind of electoral system we want.
I thought the laws are supposed to help answer those questions.
But that is you don't start by changing the law.
Oh.
You start by actually building consensus around these issues. There have been discussions about proportional representation. To do what? To make the process up. This whole winner-takes-all mentality, this whole winner-takes-all approach, this first-past-the-post system is what is responsible for some of this over-concentration of power, misuse and abuse of power, and also imposition of candidates. The reason why everyone is defecting to one political party, it's because you do not have a process where even if you secure a certain threshold of votes, you can still have representation, in the National Assembly. It's winner takes all. It's this winner take all mentality that is driving politicians to go under a particular platform where they feel that they are guaranteed electoral success. Whether that success is gotten legitimately or illegitimately, they don't care. So we need to have that conversation. And Justice Uwe's report clearly shows us a pathway that we need proportional representation. That way, you devolve, you decondense, and you decentralize, you share power. You cannot concentrate power in a particular institution and a particular enclave for a long period of time. So those are the things. And then you look at this whole discussion, about our electoral system and the cost of our cost of elections. There are just so many things that we need to ask. We need to look at an institution like INEC and say to a large extent, do we need an INEC that is constituted by the executive? Do we need state independent electoral commissions that are constituted by the governors? Shouldn't we think about a new approach? These are the bigger questions. We need to have a consensus before we go into making those laws. But if you don't have consensus, unfortunately, I don't have a culture of building bipartisan consensus on these issues, because all of them and the political class, they are all the same. All they think about is the next election. How do they secure power? And I bet you, we have not gone past 2027, but people are already talking about 2031. No country develops that way. You've got to ask yourself the questions about what are we doing today? How are we securing, tomorrow? Look at the 2022 Electoral Act. It was the best piece of legislation, we've ever had in terms of our electoral jurisprudence. This 2026 is one of the worst. And that's why parties are struggling. Because, for heaven's sake, why do you limit the mode of the candidate selection to only two modes? Consensus and direct primaries. This was not discussed with stakeholders. It was the preference of either one man or two people or three people. The entire reform process, this was not an issue. But when it came to the final, at the dying minute, maybe because a set of individuals, and this is the problem, when a set of individuals decide to impose their own preference as our collective preference, rest assured you're going to get opposition, to it. These are the fundamental issues we were talking about. If you look at the whole results management process and how it was managed, you clearly see that the whole amendment process was botched at the dying minutes. Despite the fantastic work that the committees did, when it came to vote, they started. So these are the issues that we really need to look at. But you know what, Larry? You can amend this law, right, to any extent. If our political class don't change their attitude, you're never going to see any
But
change.
the point people would ask is, how do we make them change? Because if we've looked at the last 3-4 elections, a lot of blame still goes back to the political class. You said it yourself, the last 2022 act was almost perfect.
Yeah.
We still had problems with it because of the people playing in the field.
3 things can be done.
Okay.
Good people with conscience, with competence and character should not stay away from politics. A situation where, the worst of us are the ones presenting themselves as leaders. You definitely get this. So good people who have competence, who have character, should go into politics and not leave politics, for the current crop of politicians that we have. We need people to go into politics with different mindset. Secondly, voters need to actively engage this process. The only way we are going to remedy this mess is if voters make informed choices at every point in time. Because democracy does not begin and end with elections. It's about being actively involved throughout the entire electoral cycle. If you have only 25% of people showing up to cast their vote, then you have a problem. Look across board. You see that minority are determining for the majority of us. That's an anomaly. That needs to be fixed. So we need more people making informed choices at the ballot. I think the third thing is that our institutions need to be held accountable. The Constitution is very clear on what can be done. The Constitution also set red lines. When those red lines are crossed, institutions should perform their responsibility of holding those who cross those red lines to account. When you don't activate the Constitution, what you end up is a banana republic. And if we're not careful as a people, we're gradually sliding into a season and a period of institutionalized impunity. And that is the biggest challenge that we're dealing with, where politicians think they can do anyhow. They can fail and break the law. They can redraw the red lines, even erase the red lines, and there's no accountability. That is the biggest problem that we have.
Something very briefly, from what we've seen now, how optimistic are you about the 2027 election?
I'm an optimist. I wouldn't do the things I do if I don't believe in this country and I don't believe in its people. I think I'm optimistic because I see Nigerians every day rising up to say we will not accept this from our political class. That is the kind of defiance and energy that we need to push back. Because anyone who sits back and think that our politicians are going to be benevolent and they have our interest at heart, no. Democracy is about struggle. It takes consistent struggle, consistent asking questions. Sometimes we'll fail, sometimes we'll succeed. That's how democracies thrive. But for any Nigerian who sits there and think this country is going to change by sitting in your comfort zone, it doesn't work that way. Nations that have transformed, that have reclaimed their democracy, they are built on the sacrifices that people make. It will cost you something. It will cost you your time. That's why you must go out in 2027 to vote. You must stay there and watch to ensure that nobody manipulates the elections. And when it is manipulated, you raise the alarm. Work with civil society, work with media, use social media responsibly, to expose it. That is how you reclaim democracy. You don't reclaim democracy by sitting in the comfort of your homes and allowing civil society and media do the work. No, democracy is government of the people. So the people need to be actively involved. And so my charge, and what gives me hope, is actually the Nigerian people asking the right questions at the right time. And taking action. That's more important. Always a delight. Thank you very much.
Well, that is our discussion tonight. As we look ahead to the 2027 general elections, there remains many possibilities, both in the political process and in the legal challenges that may arise. As my guest has highlighted, these developments will continue to shape the democratic journey, and we'll be monitoring them closely. We'd love to hear from you. Share your reactions, your questions, and particularly your thoughts on the party primaries you've witnessed so far. Just send them in through our social media handles and the email address displayed on your screen. Now, for past episodes, simply search Newsnight on our YouTube channel, click on the playlist, and just take your pick. Thank you for staying with us. From all of us here, I'll say stay safe and good night.